It's changed pretty much everything. I haven't been able to function like normal. I just now started walking without a cane. I just remember trying to get out of the car. I thought it was on fire. I didn't have my glasses on anymore. And I couldn't see very good. I tried to get out of the car and hit it. And that's when my leg's broken. It changed everything. They didn't get dressed. And it's a day-by-day thing, even though it's been 6 months, it's still hard to sometimes get up, do normal things, even if it's going to get a drink of water.
If I could just, get the case dismissed because it's not.
Yeah, well, it would be lovely if cases could just be dismissed because it's not true, right?
Right.
But we don't know. What we have is your word versus her word at this point.
Right.
And so that creates a question of fact.
We've already worked out a package deal and we're waiting on this case to be issued and him be arraigned. So both cases can go to Judge Buchanan and be set for a plea and sobriety court.
So we're doing it all today.
Okay.
There's no reason why we wouldn't.
That was my request, Your Honor. Hear all the testimony and then rule separately on the motion.
Sounds good. I'm sure it's all the same information. So.
Correct.
Thank you. You can proceed.
The people call Stephanie Randall.
Do we have more than one witness in the courtroom? Oh. Other right hand. Please solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Yes. Okay, you can have a seat. You can state your first and last name and spell both.
Stephanie Ringo, SEFANIE
Okay, there's a microphone that's in front of you. That microphone will not amplify your voice. So if you can keep your voice as loud as possible, that would be great. If either of the attorneys make an objection, you will stop speaking immediately. I will make a ruling on that objection and then I will tell you if you're allowed to answer the question or not, okay?
Okay.
If you have a question posed to you that calls for a yes or no answer, you must answer yes or no. A no head nods, head shakes, because we can't articulate that into the record. So if you forget, I'll just ask you if that's a yes or no, okay? Okay, you can proceed, Counsel.
Thank you, Your Honor. Good afternoon, Ms. Randall. How are you? Good. Good. I know it's a little bit of a bummer to be in court under these circumstances, but I'm hopefully get you out of here pretty quick and let's just talk about the matter that brings you to court today, right? So first, I want to start off by asking on November 9th, 2025, were you involved in an accident that was near Martin Luther King and Olds Avenue?
Yes.
And can you tell us, can you describe for us, just in your own words, what happened at that accident?
I had just picked up my wife from work and we're driving. I just glanced down at my speedometer and I looked up and collided with the person ran the.
Okay. And did this accident happen in the city of Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
Okay. And where were you going to? You said you just picked up your wife?
Yes.
Where were you guys going heading to after you picked her up?
Excuse
And
me? Can you speak up a little bit for me?
I'm sorry. We were going home.
and you said the individual ran the stop sign? And then you said you.
I'm gonna object to that speculation, whether she ran it or stopped it for proceeded.
Call speculation.
Speculation.
Okay. Did you see her run the stop sign, ma'am?
Yes, because when I glanced up, I saw her going much faster and I didn't have time to stop.
You saw her going much faster?
Yes, she was fast, like she didn't stop at the stop sign and there was me and a bunch of other cars behind us. It was a one-way street and I just saw her go right in front of us.
Okay, so what your testimony is that you were able to visualize her as she approached the stop sign and
She
then
was already, sorry.
Oh, you gotta wait until she's done.
as she approached the stop sign and that you also visualized her just not stop and continue to go through, or did you take your eyes off her and the next thing you noticed is that she was through the stop sign?
I had glanced down at my speedometer and looked up and just saw the car SUV going past the stop sign.
So did you see her stop at the stop sign or no?
Did you see her prior to she got to her getting to the stop sign?
I had saw the car on Old Road because I was one of the first cars in like the wall of traffic. And when I glanced down, I had made sure everything was fine, glanced down, glanced up, and that's when I signed on the brakes.
I'm gonna sustain the objection because I believe it does cause for speculation.
And the individual that you saw in the SUV, is that individual present in court today?
I don't know. I never saw it.
Okay, okay, so after, the individual came to the stop sign, what happened in that next?
I remember the impact. And then somebody was talking to me. I think it was the other lady that got hit. I just remember trying to get out of the car. I thought it was on fire. I didn't have my glasses on anymore. And I couldn't see very good. I tried to get out of the car and put it. And that's when my leg was broken. And then the paramedics got me into the ambulance.
Take a minute if you need me, okay?
Sorry.
No problem. I know it's hard to recount that, so just take a minute.
Answer your question.
Yeah, no problem. So as a result of the accident, did you sustain an injury?
Yes, my tibia, I had an open fracture of my tibia and my fibula.
And were you transported to the hospital as a result of the accident?
Yes,
And how long were you in the hospital?
a week. About a week. On the 10th, I had surgery. I'm
Speak up.
so sorry.
Yeah, no
Yeah,
problem.
it was a week.
Okay. And what type of surgery did you have?
They put a rod through my tibia and just rod and screws and where the bone comes out.
And you were in the hospital for a week, you said?
The first time. The second time I was in for another week because I got an infection from where the bone had broken the skin. So we had to do another surgery.
And how long were you in hospital that time?
Also,
A week as well. And I would imagine this was very painful.
Objection. Speculation.
I think that's a question,
It's
though.
not a question.
Yeah, is it a question?
Was this the breaking of your leg? Was that painful?
yes.
So at this time, have you healed from the accident?
I'm still going for physical therapy, and I have another appointment with my ortho and the disease specialist on Tuesday.
Did you, were you prescribed any medication based off of?
Yes, I had to have a PIC line for 6 weeks for the antibiotics for the Staphylococcus aureus that I got from the initial break.
And how's the accident affected your life?
It's changed pretty much everything. I haven't been able to function like normal. I just now started walking without a cane.
Take your time.
Changed everything. Bathing, getting dressed. And it's a day by day thing, even though it's been 6 months, it's still hard to sometimes get up, and do normal things, even if it's going to get a drink of water. Being in a car is terrifying.
And last question, how long is did they say the rehab for your break? How long is that?
I have, they reevaluate me every 4 weeks. But so far it's been ongoing since February.
So there's no definite date.
No,
Okay, no further questions.
I have no questions, Your Honor.
Okay, you made the excuse me, I'm thinking. Thank you. It's part of the rest of this.
People call Officer Haven Hyatt. There's some black chairs and it's regular signature.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
yes, ma'am.
United States. You state your first and last name and spell both.
First name is Haven, last name is Hyatt, H-A-V is in Victor, E-N is in Nora, H-I is in Ida, A, 2 T's is in Tom.
Thank you, Your Honor. Officer Hyatt, I understand that you were recently married.
Yes.
Congratulations. So hopefully we'll be able to get you back out of here pretty quickly and so you can continue that honeymoon period. So I'm gonna need to
Are you
pull
on
up
the
the body
Zoom?
camera.
Are you in the Zoom?
Yes.
This is State of Michigan versus Daryl Morris, 25-03133. Of your appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of people.
Good morning, Honor. Attorney Derek from the Office of the Public Defender on behalf of Mr. Morris is in the courtroom standing to my right.
Mr. Morris has the operating while intoxicated third offense that was scheduled today for I believe, for probable cause conference. Looks like, however, it says he picked up another OWI. I was screened for sobriety, but what is this? Yes, OWI third, I have it here. File number 26-01100. Felony complaint here that alleges that on or about February 19, 2026, at the area of North Pennsylvania and Persons Court, which is in Lansing, Michigan, Lansing, Michigan, Ingham County, that you did allegedly in count one commit the act of operating while intoxicated or impaired. There's a third or subsequent offense notice attached to count one. It said the defendant did operate a vehicle upon a highway, that being North Pennsylvania Avenue, while under the influence of alcohol, liquor, and or having an alcohol content of 0.08 grams or more per 100 milliliters of blood, contrary to Michigan Compiled Law 257.6251. That's a misdemeanor normally. Maximum penalty is 93 days and or $100 to $500 in fines and or 360 hours of community service and rehabilitative programs, and vehicle immobilization is mandatory with a prior conviction, and cost of prosecution reimbursement to the government for emergency response and expenses for prosecuting the defendant may be ordered. There is, however, again, a third or subsequent offense notice, which enhances the count one to a felony. Says take notice that the defendant was previously convicted of operating while impaired on or about February 12th, 2009 in the 55th District Court, and of operating while impaired on or about September 10th, 2009 in the 55th District Court. Therefore, upon conviction, the defendant will be subject to an enhanced sentence under MCL 257.6259 or MCL 257.62511, and vehicle forfeiture under MCL 257.625N. That's a felony. Maximum penalty is $500 to $5,000 in fines in either 1 to 5 years, or probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days of community service, rehabilitative programs, and cost of prosecution reimbursement to the government for emergency response and expenses for prosecuting the defendant may be ordered. There is a mandatory vehicle immobilization of not less than 1 year or more than 3 years unless the vehicle is ordered forfeited under MCL 257.625N, and a term of imprisonment imposed must not be suspended unless the defendant agrees to participate in a specialty court program and successfully completes the program. Do you understand the charge and the maximum penalty as well as the enhancement? You have the right to counsel. You have the right to a public defender. If you can't afford to hire an attorney, you can make a request to have the public defense represent you at the expense of the public. Again, this is being enhanced to a felony, so you have the right to have a preliminary examination within 21 days of today's date, unless you waive the timeline or the court finds good cause to go beyond the 21 days. At the time of the exam, you have the right to have the prosecution establish that they have sufficient probable cause. You can remove your hands from your pocket in court. Thank you. A sufficient probable cause that a felony was committed, and probable cause sufficient to charge you as the individual who committed the felony. If this matter continues beyond the preliminary examination, you have the right to trial, the right to a jury trial, the right to be presumed innocent until proven guilty, the right to maintain your silence and have the prosecution call witnesses that you can cross-examine at court or question, the right to subpoena witnesses that will testify on your behalf, and the right to not have the silence be used against you. You understand that? He's requesting public defender on this one as well, correct?
Yes, Your Honor.
Court will enter a plea of not guilty on your behalf. You're currently scheduled for probable cause conference before me on May 22nd at 8:30. You have a preliminary examination, May 29th at 8:30. Both are scheduled for in-person appearance, okay? Again, the court is into a not guilty plea on your behalf. Is your address changed from the Paris Ave address? What's your phone number?
517-226.
Where are you employed?
What's what?
West Rock?
Yes,
What is that?
it's a friend company.
Okay, so the allegation or the alleged date of this is February 19th, which is the date he was arraigned on this one, so it's not a bond condition issue on this. This was probably just waiting for the lab results or something.
Your Honor, I'm not sure of the status of what they were waiting on to issue it. I do know that we adjourned your original case several times because he has been accepted in the sobriety court. And
once someone sees a path that could reduce punishment, protecting that option becomes psychologically powerful. But specialty courts work on strict compliance. The danger here is that every new allegation raises the cost of trust. At this stage, the court is not just evaluating intoxication charges, it's evaluating whether the defendant can reliably function inside supervision.
We've already worked out a package deal and we're waiting on this case to be issued and him be arraigned. So both cases can go to Judge Buchanan and be set for a plea in sobriety court. It's my understanding the plea agreement would entail one of the files being dismissed and then pleading to the other file.
Yeah, it was waiting for lab results. He was arrested on the drunk driving in 26-01100 on February 19th. But it looks like the file number ending in 3133 was already pending. He had failed to appear for arraignment. So they arraigned him while they had him in custody, but they still needed lab results on this one. So I was just trying to see if this was picked up while he was on bond, but that's not what happened. So both of these matters are supposed to be transferred to Judge Buchanan for sobriety court.
Yes, Your Honor.
Okay. Our bond conditions will be identical to the conditions in the previous file. He's not to travel outside the state without prior approval of the court. He's not to use drugs or alcohol, not to possess a firearm, ammunition, or weapon of any kind. He is going to be required to participate in random weekly preliminary breath testing. 2 random ETGs monthly. Is there any other date when he's gonna be before we can? Okay. I just know this was some transfer, she takes the play anyway, so. I hope that this will be transferred to a sobriety court. You'll enter a plea before Judge Buchanan, okay? Any additional matters for the record?
Nothing from the people, Your Honor.
For the bond, Your Honor, what was the bond?
The bond is set, again, identical to the other 750 personal recognizance.
All right, thank you. Your Honor. No further questions.
No problem.
I have to file some concepts and do the bond. And
Did he do
then,
fingerprints on
yeah,
it?
do fingerprints.
Okay, he has to hang tight because he's got to get fingerprinted and we gotta get a bond process from this. Is Dennis Dickey here?
Yes, ma'am.
State of Michigan versus Dennis Dickey, 26-01116. Council, may I have your appearance, please?
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people of the state of Michigan.
Mr. Dennis Dickey.
Yes, ma'am.
Okay, you're here for a probable cause conference on an assault with intent to do great bodily harm, less than murder, or by strangulation. And then there are 2 misdemeanor counts, 1 of domestic violence, 1 an assault and battery. It appears that you applied for public defense representation, but you were denied. So you have a couple of options as it relates there. You can appeal the denial if you believe that you failed to provide all of the financial information that they needed to make a accurate decision about your financial status. Or you can hire your own attorney, or you can waive counsel and represent yourself, which is not advised. How would you like to proceed?
I would like to reapply.
You want to appeal the denial?
Yes, ma'am.
Okay. I'll find out how. I think you just contact their office to do an appeal, but I'll ask one of the public defenders here to get you better information in just a moment. It looks like I have here. I already addressed this. This is the one that went out of town.
Yeah.
Okay, you work as a truck driver,
Yes,
correct?
ma'am. Yes, ma'am.
Okay, I think I've already addressed your bond, that you are on Tether.
Yes, ma'am.
Okay, so I've addressed it so that you are allowed to travel outside of the state for work purposes. You just need to notify us in advance where you're going so that it won't trigger a violation, okay?
And is it any way possible that I could get the tether off? Because even with this case that's going, Anita, my wife, she called down there to get the tether. I was in county. She called down there to have me have it.
She called down there to have you have what?
The tether.
Okay.
And we're supposed to have a no contact. She was getting me out. So is there any way that I could,
She was getting you out of what?
when I was in county? Yes, ma'am, I'm sorry. I was in county.
You were in lockup, yeah.
Lockup, yes, ma'am. And we're not supposed to have a contact. And she called to have me, but I couldn't get out until I had this tether.
Okay.
So if I could just, get the case dismissed because it's not true. I can
Yeah,
prove
well,
it now, but-
it would be lovely if cases can just be dismissed because it's not true, right?
Right.
But we don't know. What we
Right.
have is your word versus her word at this point.
Right.
And so that creates a question of fact. And so we have to move forward. And if it goes all the way to the jury, then the jury decide
Right.
which one is the most credible side. But we didn't even get to that stage yet.
Okay.
We have to have a probable cause conference, which is today, which is scheduled for today. But you don't have an attorney, so I'm gonna give you an opportunity to appeal the denial. And then I'm assuming the alleged victim is, or at least one of them is your wife.
Yeah, and Hannah, the stepdaughter.
Okay. Okay, so we will give you an opportunity to appeal that. We'll treat next week as another probable cause conference.
Okay.
there an offer that you wanted to disclose at this time, or we're just gonna continue to PCC?
I will continue to PCC, Your Honor.
And did you want to address his motion to remove his tether?
We defer to the court.
I don't think I have any, I don't have his criminal history. Do you have any prior convictions? Are you able to see that, counsel?
Yeah.
You didn't give me a pre-trial release.
Yes, the defendant has no prior criminal history on the CCA.
Okay, thank you. I'll grant your request to have the tether removed. You have to go back down to county so they can remove it. There's no contact order, will continue though. And we'll see you next week for another probable cause conference. Let's see. How does he appeal? Okay, you just call the office and counsel.
Yes, Your Honor. I happened to look up Mr. Dickey's file while I was here. It appeared he called and spoke to someone regarding the denial, I think, on April 28th.
Okay,
And provided some either new or additional information that was reevaluated and was determined that he was still not eligible. So he is certainly welcome to contact our office and apply or reapply, but unless there's been some change in his financial circumstances, see that he would qualify.
I applied today. I reapplied.
you reapplied today. Okay, so it's likely, just given your employment, that you may just make too much money for public defense. The threshold is not very high. Okay, and so we will navigate that after we figure out what happens if you just reapply today, what will happen. Okay, do you have any other questions at this time?
No, ma'am, but you did say I could get the.
You can have the tether removed,
Thank you.
and then because we're gonna treat next week as another probable cause conference, you do not need to appear in person, okay? You can appear via Zoom.
Do I have the date? This is it.
That's your next week's date. That's correct. Any additional matters for the record?
Not
counsel?
from the people, Your Honor.
You're all set, sir.
Thank you.
These hearings look procedural on the surface, but they reveal something much bigger about how courts measure risk. In one case, the judge is managing repeated alcohol-related allegations while balancing punishment against the possibility of rehabilitation. In another, the court is dealing with domestic violence accusations where the defendant wants immediate relief before the evidence has even been tested. And in the crash case, the courtroom shifts entirely toward consequence, not punishment alone, but the lasting impact left behind after a single moment on the road. What connects all three is that the legal system responds less to explanations and more to patterns. Courts look for consistency, compliance, credibility, and whether someone follows structure once they are warned about the stakes. That's why small decisions inside these hearings matter so much. Missing conditions, minimizing allegations, or assuming the court will simply understand can quietly damage leverage long before trial ever happens. You can also see how judges separate emotion from procedure. Sympathy may exist in the room, but procedure still controls the outcome. The court keeps moving step by step: probable cause, eligibility, supervision, credibility, evidence. That process can feel slow to defendants, but legally it's designed to prevent decisions from being made purely on accusation or denial alone. And by the time many people realize the court has shifted from giving options to enforcing consequences, most of the important decisions have already been made. Sometimes the turning point in a case is not the final ruling, it's the moment the court decides whether you can still be trusted with another chance.